Hello, Assalamualaikum everyone. This is Fathia and Fina partnership. This is me, Shamina Hanan binti Saharuddin, and my group members, Alia Nurul Farisha, Nurul Atia Farhana, and Fizatul Hasmaniza. And today, we're gonna talk about intentional torts, which is trespass to the person, trespass to goods, and trespass to land. The first question is about Lan goes to Tidi's barbershop. Consider Lan's liability in trespass if the following incident happened. Without looking, Didi throws away a lighted cigarette. It falls on Lan's head. The hair cream used by Lan is inflammable, though it is known to the maker. As a result, Lan's hair catch fire and he is severely burned. Would it make any difference if Lan is being sued in trespass or negligence? The issue for the first question is about whether Lan can sue Didi under trespass to person, which is battery, and negligence under law of torts. The question number 2 is about Lan goes to Didi's barbershop. Consider Lan's liability in trespass if the following incident happened. Suppose that in the above problem, Lan was sitting behind a bush and his presence was unknown to Didi and could not be foreseen. Is Didi liable to Lan? Explain why. So the issue in this question is about whether there is a direct physical contact between Lan and Didi. The last question is about Lan goes to Didi's barbershop. Consider Lan's liability in trespass if the following incident happened. Suppose Didi argues that Lan's hair caught fire because of the hair cream was inflammable and Didi knows. Therefore, Lan alone is responsible for the injury. Can Didi's argument succeed? So the issue in this case, whether Didi argues that Lan alone is responsible for the injury is valid.
Question 5. Lan goes to Didi's barbershop. Consider Lan's liability in trespass if the following incidents happen. A. Without looking, Didi throws away a lighted cigarette. It falls on Lan's head. The hair cream used by Lan is inflammable, though it is known to the makers. As a result, Lan's hair catches fire and he is severely burned. Would it make any difference if Lan is being sued in trespass or negligence? So, the legal issue for this case is whether Lan can sue Didi under trespass to person, which is battery, and negligence under law of torts. So, let's move on to the next slide, shall we? So, the law applied for this case is, as for trespass to person, which is battery, it can be successfully defined as an intentional and direct application of force, including body parts and objects, to another person without the person's consent. There are 4 elements that need to be fulfilled in order to establish battery. Firstly, the mental state of the defendant. The defendant must have applied force or physically touched the plaintiff with intention to hurt. No violence is necessary and any physical contact with the body of the plaintiff or his clothing is indeed sufficient to constitute force. Secondly, the defendant's act was under his own control, in which the defendant's actions must be done voluntarily. This can be seen in the case of Gibbons and Pepper. The material facts were the defendant was riding a horse when someone hit the horse from the behind, causing the horse to bolt. The horse then collided with the plaintiff. The court later held that the defendant was not liable for battery as the action of the horse bolting was outside his control. Next, there must be contact or touching with the plaintiff's body or clothing. In the case of Cordins and Wilcock, a police officer held a woman with the intention of temporarily detaining her. Later, the police officer was found guilty as the contact was indeed hostile and he did not have the authority to detain her. Lastly, without plaintiff's consent. It further stated that one cannot touch another person without his consent as well as without lawful justification. This can be elaborated in the case of Nash and Sheen. The plaintiff went to the hairdressing salon where the defendant used the tone rims without first obtaining the plaintiff's consent. The plaintiffs unfortunately developed some skin complications due to an adverse reaction to the tone rims. It was then held that the consent given by the plaintiff did not include the tone rings and its consequences. Therefore, battery was established. Let's move on to the next slide, shall we? As for negligence, according to Winfield and Jolowitz, negligence is indeed a breach of legal duty which result in damage undesired by the defendant to the plaintiff. In simpler terms, it is a failure to exercise the degree of care that a reasonable person would have exercised. A cause of action in a matter of negligence is clearly explained in the case of Bank Bumiputra Malaysia Berhad and Tetuan 1 American Hamzah and Shai and others. A cause of action in negligence arises on the date the loss is suffered, and in cases where the damage is latent, the date the damage comes into existence and not the date when the damage is discovered. There are three elements required to establish fault of negligence. Firstly, the defendant is under the legal duty of care to the plaintiff, in which a person is only liable for negligence if he is under a legal duty to take care. Duty of care means an obligation or burden imposed by the law which requires a person to conform to a certain standard of conduct. This can be seen in the case of Donahue and Stevenson. The defendant, a ginger beer manufacturer, had sold ginger beer in opaque bottles to a retailer. A friend of the plaintiff had purchased the beer from the retailer. The plaintiff then consumed half and poured the remaining into a glass and found a decomposed snail in it. As the bottle was opaque, the plaintiff could not see the snail earlier, and as a result, the plaintiff became ill. It was then held that the defendant, as a manufacturer of the ginger beer, owed a duty of care to plaintiff as a consumer. The duty included ensuring that the drink did not contain any noxious substance which was likely to cause injury to anyone who drinking it. It is important that the defendant did not know the plaintiff, as long as the plaintiff belonged to one of the classes within the area of foreseeable injury. Secondly, there must be a breach of that legal duty of care by the defendant. Breach occurs when the defendant does something that is perceived to be below the minimum standard of care required of him, which is measured through the standard of a reasonable man. In the case of Muhammad Raihan bin Ibrahim and another, and government of Malaysia and others, the plaintiff was injured by a hair wielded by a few people during a practical gardening class. The plaintiff alleged the defendants had failed to give adequate supervision as well as instructions regarding the use of gardening tools. Later, the federal court held that the defendants were negligent as they had failed to take reasonable steps to prevent injury to the plaintiff who was under their case. Lastly, the plaintiff had suffered damage as a result. Even though the defendant had breached his duty of care, the plaintiff can only claim for negligence if he can prove that he had suffered damage because of the breach. The damage caused by the breach must be foreseeable or can be anticipated and must not be too remote. So let's move on to the next slide, shall we? So, the application for this case is Lan definitely can sue Didi under both trespass and negligence under law of torts, as he directly put Lan in direct and imminent harm since he threw away a lighted cigarette which accidentally later fell on his head, causing severe burns to him. Didi can be sued under battery as he had established all four prerequisites of battery. Didi had applied force with the intention to hurt Lan, and there is direct physical contact between him, which is the lighted cigarettes itself, with the body of the plaintiff. The unnecessary action of throwing the lighted cigarettes was also done under his own control and voluntarily, without the consent from the plaintiff. Didi, however, can also be sued under negligence as he had fulfilled all three elements of negligence. Didi, as the owner of the barber shop, indeed had the legal duty of care towards Lan, his customer. In this case, he failed to exercise, thus breached his legal duty of care as he did not manage to give protection and safety to their customer. He was supposed not to throw away lighted cigarettes as he had the knowledge that the lighted cigarette itself can give harm to other people. The plaintiff indeed suffered damage as his head was severely burnt due to his careless wrongdoing. As for the conclusion, Lan has the power to choose whether to sue Didi under trespass to person, which is battery or negligence, as Didi is liable and had fulfilled all the important elements under both offences under law of torts.
Basically, the case we refer for the first question is Bank Bumiputra Malaysia Berhad and Tetuan Wan Marikan Hamzah and Sheikh and others 1994. Next, Donald Hugh and Stevenson 1932, AC 562. So the conclusion for the first question is Lan can sue Didi under trespass to the person whether on battery or negligence, as Didi was liable and had fulfilled all the important elements under both offences under law of tort.
Assalamualaikum. My name is Nur Atiafana binti Asari. My matric number is 1222119. So, for question 5B, which is Lan goes to Didi's barbershop. Consider Lan's liability in trespass if the following incidents happen. Suppose that, in the above problem, Lan was sitting behind a bush and his presence was unknown to Didi and could not be foreseen. Is Didi liable to Lan? Explain why. So the issue here is whether there is direct physical contact between Lan and Didi. As long as the lighted cigarette land on Lan, there is a direct physical contact, and Didi can be sued under battery, which is under the law of tort. There are three elements in establishing battery. First, direct physical contact. Second, intentional physical contact with plaintiff. And third, unjustified physical contact with plaintiff. For the first element, which is direct physical contact, the physical contact between Lan and Didi must have been caused by a direct act of Didi. Didi's act also must be voluntary, which means he can control his act at that time, and the result of the damage is the result of his conscious acts. Next, in order to establish battery, the second element must be fulfilled, which is Didi's physical contact with Lan is intentional. In order to know whether Didi's act is intentional or not, we must use the reasonable man's test. And the third one is there must be unjustified physical contact between Didi and Lan, which means the act of Didi is without the consent of Lan. In this instance, without a doubt, the first element has been established when the lighted cigarette land on Lan, which causing severe burn to Lan head. Didi's act also has been done voluntarily without any compulsion. For the second element, which is does Didi intentionally having a physical contact with Lan? To establish this element, we can refer in the case of Collins and Wilcox case. In this case, they use the reasonable man's test to know whether the physical contact is intentional or not. In this case, a police officer wished to question a woman in relation to her alleged activity as a prostitute. The woman decided to walk away, but the police officer was intent on stopping her, and in order to do so, the police officer grabbed her in arm in order to prevent her from walking away. Under the Street Offences Act 1959, Section 57, the police officer had no power to detain the woman. The woman struggled with the police officer and scratched him. She was charged with assaulting a police officer in the course of his duty. The issue in this case was whether the conviction for assaulting a police officer was lawful given the lack of legal authority on the part of the police officer to restrain the woman. In its judgment, the court decided that the police officer exceeded his authority because he couldn't arrest the woman in that situation. The court also determined that the officer's grabbing without the power to arrest was a battery. The court also clarified that the battery means touching someone with hostile intent or any intentional touching that goes beyond what is typically acceptable. With that being said, as a reasonable man, we wouldn't throw a cigarette into a bush as it might catch fire easily, which means Didi's act is absolutely intentional as it is the result of his conscious act. For the third element, there must be unjustified physical contact between Didi and Lan. Unjustified physical contact means the act was done without the consent of the plaintiff. For unjustified physical contact, we can refer in Nash and Sheen case. In this case, the plaintiff went to the defendant hairdresser and requested for a perm. Instead of a perm, the defendant gave the plaintiff an unwanted tongue rinse or hair dye, which caused rashes on the head of the plaintiff. It was held that the defendant was liable for battery. In this incident, logically thinking, Lan would never ask Didi to throw the cigarette on his head. This shown that there's an absolute unjustified physical contact between Lan and Didi. In summary, Lan's lawsuit under battery against Didi for trespass is likely to be successful as all the elements to sue under trespass to the person, which is battery, have been established.
For the issue number 2, we refer to the case firstly Collins and Wilcock 1984 and case Nash and Sheen 1953, where the application was direct physical contact with plaintiff and intentional physical contact with plaintiff and unjustified physical contact, where the conclusion for the issue number 2 is Lan is lawsuit under battery against Didi for trespass is likely successful as all the necessary elements has even established.
Assalamualaikum warahmatullahi wabarakatuh. My name is Tasmin Liza binti Mahathir. My metric number is 1222120. For the question 5, Lan goes to Didi barbershop. Consider Lan liability in trespass if the following incident happened. C. Suppose Didi agrees that Lan hair caught fire because of the hair cream was inflammable and Didi knows. Therefore, Lan alone is responsible for the injury. Can Didi agreement succeed? The issue arises here is whether Didi agrees that Lan alone is responsible for the injury is valid. Didi argument did not succeed because Lan can establish that Didi act of throwing the light cigarette was a direct cause of the fire. The concept of proximate causation is essential in determining liability. Even if the hair cream was inflammable, if it can be demonstrated that directly initiated the fire, Didi action might still be regarded a proximate cause of Lan injuries. For the case law, in the case of Scott against Sheffield, the defendant threw a skip, which is a small lit firework, into a busy marketplace with lots of people installed. In order to protect themselves and avoid damage, the skip was thrown on by the two other people. When it landed near to the complainant, it exploded and caused injury to his face. He later lost the use of one of his eyes. The original thrower, the defendant, was charged with assault and trespass. The defendant was found liable for trespass and he appealed this decision. The defendant argued that the injury to the complainant was not caused by his action. It was not direct act, as others threw the skip on. The issue in the appeal was whether the defendant throwing the skip caused the injury or whether other people broke this chain of causation and the injury was caused by novice actors' intervenence. The court dismissed the appeal. The injury to the complainant was the direct and unlawful act of the defendant, who originally intended to throw the skip. The other people were not free agents in this situation and threw on the skip for their own safety, and this was justifiable. The throwing on was classed as a continuation of the defendant action which was intended. Therefore, Didi agrees that Lan alone is responsible for the injury because of the hair cream was inflammable is not valid.
Therefore, for the issue number 3, we refer to the case Scott and Shepherd 1773, where the case shown that Didi's argument didn't succeed because Lan can establish that Didi's act throwing the lighted cigarettes was a direct cause of the fire. So, at the end, the conclusion is Didi agrees that Lan alone is responsible for the injury because of the hair cream was inflammable is not valid. Thank you for your attention, and that's all from us. Bye!